So, good morning everyone. I am your host Animesh Gupta, and along with me is my co host Lokhande. We from the Legal Aid Committee of the Maharashtra National Law University Nagpur are conducting this podcast on the constitutional rights of tribal communities. As our guest, today we have Dr. Rajesh KP, who is an assistant professor of sociology at the Maharashtra National Law University Nagpur. For getting an academic context of the tribal rights communities and their constitutional rights, my first question to you, sir, is how did the colonial legacy, if we go historical perspective, influence the current constitutional protections of the tribal communities, and what is the origin of the term scheduled tribes in India? How did this terminology evolve in the current framework of the Indian Constitution, and what socio-political factors influence the classification of such certain indigenous groups under this category?
Yeah, thank you for this opportunity to have a conversation with you. See, if you go back to the history of colonialism, specifically the history of British colonialism, in which, there was some kind of an understanding about a cultural exceptionalism, probably a theory or a notion around cultural exceptionalism, around which British colonialism identified certain sections of the aboriginal people in our society. Some were primitive in nature, they are savage in nature, probably they are nomadic in nature. Some of the communities are nomadic in nature. So this tribe was, the notion of tribe was always conceived in connection with the modern idea of British, or the modern idea of European people, where it was largely an Orientalistic understanding around which they were looking at the primitiveness of the tribal community. So we found that this primitive is a very problematic category at a later point. Right, this primitive is always conceived as an inferior to the modern European people, right? Especially when you look at the categorization of tribal people. And see, that is where probably if you look at the larger history of colonialism, where they always located these sections of the people as extremely problematic in nature, right? And sometimes at some point, probably they invented the category of criminal tribe, right? By specifically looking at the tribal people where they had a specific practice that was existing, especially the hill tribes, where they are usually coming to the plains and raiding the plains, right? And taking some of the things which was some kind of a customary right that was existing, right? But according to the idea of colonialism, this is extremely a sort of criminal activity, and this is an offense according to them. Then they probably invented this category that these people are criminal in nature. Therefore, there is some kind of a criminal tribal identity attached with those sections of the society. So this is broadly, this is the way in which probably colonialism invented this category called tribe in our society. So this was an administrative category, and now we know that administrative category was still existing, the administrative category with a different meaning, right? But also we have developed categories like Adivasis. We have, if you look at international context, probably you will find indigenous people is another category that is strongly coming in, right? But still, that is also a contested area around which, right, the debate that is going on, that's whether the idea of indigenous, how far the idea of indigenous, that is probably relevant when we are talking about tribal community, or the notion of tribe, which is existing in India, right? So I would say that this is the larger history of colonialism. And also, suppose if you look at this 1878 Forest Rights Act, probably you will find that whatever the customary rights that was existed among the tribal community in connection with the forest as well as forest resources, that was largely curtailed through this legislation, and that was revised in 1927, where they have, I mean, of course, British colonial regime was clearly having an agenda of exploiting the natural resources as well as forest resources, where they thought that tribal community definitely would be an obstacle to go for that kind of an excessive exploitation in our society. Probably this is the way they have, I mean, expelled tribal community from their natural habitat to a greater extent during the colonial period.
So thank you for your answer. So as you said that the colonial history has influenced the tribal communities, but how can we relate this with the current constitution of India with specific protection which are given to tribal communities under Article 371A and 371G, which provides the tribal communities special protections, and how effective they have been in safeguarding those tribal communities till date. Also, how these provisions have elevated the poverty, reduced literacy, and addressed the social and economic isolations which were faced by them, as you said, that they were exceptionalized.
Right. How this was incorporated as part of our current constitution, where you have to go back to the history and look at a prominent debate between Jawaharlal Nehru, I mean, the first Prime Minister of India, Pandit Jawaharlal Nehru, and a prominent anthropologist known as Warrior Elvin, right? Because in Nehru's imagination, of course, Nehru's imagination was largely connected to the colonial, to a greater extent, I would say, connected to the colonial imagination, where Nehru was also thinking that, these sections of the society are extremely backward in nature, right? And India wanted to be a modern, developed country. So the idea would be you have to assimilate these people to the mainstream of the society, where on the other hand, if you look at the anthropological understanding of Warrior Elvin, probably he was looking at tribal community by looking at the cultural specificity of that community, identity of the community, their belief system, their language, their ritualistic practices, etc. I would say that is both of them are equally problematic, right? Because when you say that is this community, by following Nehru, these communities should be assimilated to the mainstream of the society, where there is an implied connotation of a forceful incorporation of that community to the mainstream, right? So that is where probably a large number of the people, I mean, disagreed with Nehru's imagination of integrating that community. We can integrate with the community, but I mean, how that integration would be possible, right? That integration definitely should not be possible by using the coercive power of the state, right? This is what we discussed for some time. So that is why I'm saying that is, if you look at the initial idea, that initial idea to some extent was there in the constitution also, that these sections of the society is some kind of a isolated community, right? Different from the mainstream of the society, deviated from the mainstream of the society. So somewhere along the way, we tried to set up a standard, and that standard is the mainstream of the society, around which we attempted to evaluate these communities, and our idea was integrating that community to the mainstream, where something that was largely missing in that idea was what is exactly the notion of the community, what they wanted to do in their life, right? What is exactly their relationship with the nature, what is exactly their relationship with forest, right? Where can we give some sort of a autonomy, or probably a relative autonomy to the people, so that probably they can have their own idea of democratic practices, their own idea of customary practices, etc., right, without denying the larger structure that is existing. So this was, I mean, slowly incorporated as part of the constitution. See, that's why, see, for instance, when you come to Article 371A, see, that is obvious, that is a society in which, right, 90%, I mean, this is talking about the state like Nagaland, right? And if you look at the 371G, right, so which is talking about the society like Mizoram, where one society is having more than, I mean, roughly 90% of the population is tribal population. When you come to Mizoram, the population would be almost 95% of the population is tribal population, where, of course, we have to accept the fact. I'm not merely talking about the numerical, right, in a very mechanically, we are not speaking about the number of the people, right, but the number of the people is talking something about the regional identity, right, as well as the regional existence of the people. So that if a vast majority of the people are coming from that tradition, probably we have to seriously think about, I mean, what is exactly the special provisions which we are giving to the people through the Article 371A of the Constitution. Of course, that imagination was we are giving special provision to the society. We are also acknowledging the decentralized nature of power, right? They have some kind of we are also acknowledging the fact that they have their own autonomy to take decision. If there is a dispute that is happening, probably they have an alternative, means in law you're talking about alternative dispute resolution mechanism, where of course they have their own, I mean, local dispute resolution mechanism which was evolved over a period of time. So the provision definitely, I mean, accepting some of these things, right? But when you ask this question, that is how far these provisions help them to I'm using the word develop, I mean, quote unquote develop, doesn't mean that I'm strictly following the very westernized idea of developmentalism or completely a state-centric idea of developmentalism. That is the reason, see, I'm putting the word development, I mean, in quote unquote, right? So what I'm saying is that if you look at, see, a society like Nagaland, right, where you will find almost 80% of the people are literate, right? If you look at a society like Mizoram, where you'll find almost 90 to 91% of the people are literate, right? But we cannot say that, I mean, completely we cannot say that this is resulted through the provisions that we ensured in the Constitution of India. Meaning, so if you look at Nagaland, if you look at Mizoram, they have a longer history of colonialism, especially in some of these societies, where the intervention of missionary activities played a very, very important role in educating the people. Of course, missionaries were having their own religious interest, their own interest around conversion, but of course that was also resulted in educating the people, giving them literacy. A lot of people who are, of course, speaking other languages and they have proficiency in English, all those things which is there existing. So what I'm saying is that is not merely resulted through 371A or 371G, rather it should be located in the larger historical process, right? So that is where I'm saying, see, rather than merely looking at the literacy rate of the people, probably if you go for how the local democracy that is working in the society, probably I would say that is where we need more and more empirical studies about those societies. And what I found is that still the studies are very less in number, right? Rather than, in a very, superficial manner, we are listing out some of the characteristic features of the society. But see, we have to go further and further at a deeper level to understand, right? How these things influence the life of the people. See, for instance, suppose there is a community conflict happening. See, we are saying that, we are looking at tribal community by saying that, Nagaland is having almost 89%, right? Closer to 90% of the population is tribal population. Mizoram is 95% of the population. See, the problematic idea in that understanding is that we are trying to look at tribal community is some kind of a homogeneous community where probably we are failing to understand the heterogeneity of that community, right? And that is the point, this kind of a heterogeneity that was actually raised in the recent judgment of the Supreme Court, in which you'll find the subcategorization idea which is coming, right? I find subcategorization is important in some sense, because see, a particular notion about homogenizing the tribal community is not giving us an adequate idea about the substantive equality and substantive inequality that is existing in this kind of a very notional homogeneity. So I am talking about the substantive heterogeneity of the community, based on which we need to have a better understanding about the hierarchy that is existing, the inequality that is existing in the society, and that kind of an understanding which is largely missing if you are broadly looking at the literature, right? So that is my point, right? So what I'm finally, in connection with this point, what I'm saying is that accepting this kind of a heterogeneity rather than looking at tribal as a particular class of homogeneous people is important to understand and visualizing what kind of a developmental imagination that we are going to construct, right, or we are going to develop, right? Without understanding this heterogeneity, it would be extremely difficult to have that kind of an imagination. Otherwise, the kind of development which we are always conceiving, will be benefited for only some sections of the people, even within tribal community, and a large number of the people probably left out of that process, and they are not going to get benefit out of this.
Thank you so much, sir, for your insights on how the constitutional rights have evolved for the tribal communities. However, when we talk about the constitution, it is also very imperative to talk about what the Supreme Court has held for these communities over the time period. So my question to you is that how has the Supreme Court rulings shaped the understanding of tribal rights under the Constitution of India, particularly in cases of the Forest Rights Act, and what challenges remain in ensuring an equitable development of these tribal groups?
See, that's an interesting question, where if you start with Forest Rights Act 2006, probably Forest Rights Act 2006, starting with a very important assertion, that is, this act is enacted in India by acknowledging the fact that there was a historical injustice to the tribal community, right? And also the act definitely is a landmark legislation. I would say a landmark legislation, which many people, of course, acknowledge the fact that this is a landmark legislation, in the sense that, see, we are going beyond this liberal understanding of acknowledging property rights, right? That is the predominant understanding which is there in the country. We also started recognizing the importance of individual as well as community rights and communities' rights over forest resources, right? So I would say that is something which is so significant, right? Especially when we look at the tribal community. But at the same time, right, what is happening is that, see, this is again a contention which is always happening between a section of environmentalists, between a section of forest conservers, people who wanted to conserve the forest, right, and people who wanted to have that subsistence, right? So this is actually a long debate, right? If you look at this kind of discussion between the people who are fighting for subsistence and the people whom they wanted to protect the forest, where sometimes they are located in two different positions. So that is where probably a person like Ramachandra Guha was talking about environmentalism of the poor and environmentalism of the rich, right? So environmentalism of the rich is always, I would say that, I'm not saying that categorization would be always relevant or indiscriminately relevant and applicable in all the contexts whenever you are talking about, say, there are different kinds of situation that we confronted. But at the same time, what I'm saying is that, see, when you look at a writ petition that was filed in 2008, where a group of people who are identified as forest environmental activists, right, forest conservers, right, where they argued that by utilizing the provisions of Forest Rights Act 2006, specifically by the non-tribals, because there is a provision that is, you can find traditional, apart from tribal community, traditional forest dwellers are also clearly articulated in the legislation, right, Forest Rights Act 2006, right. So by utilizing some of the provisions of the act, see, the major contention that was happened, a lot of non-tribal people started occupying the forest resources as well as the forest land, right. That is where, in 2008 they went to the court, right, and see, in 2018 there was an interesting judicial decision around the writ petition filed by this group of people. So I would like to mention some of these things from the order delivered by the former Justice of Supreme Court of India, that is headed by Justice Madan Lokur, right? So Justice Madan Lokur, by considering some of these things, he was talking about, he was saying that is, I would like to quote what he was talking about in this order, right? He was saying, under the circumstances, we issue a fresh direction to all the state governments to file a tabular statement in the form of an affidavit indicating the following things, in which they are saying, the number of claims for the grant of land under the provisions of scheduled tribes and other traditional forest dwellers, recognition of Forest Rights Act 2006, that is FRA 2006 Act, right? Then the claims should be divided into claims made by the scheduled tribes, and that should be separated from the claims made by the other traditional forest dwellers, right? This is where a lot of confusion which is happening and a lot of manipulation which is happening, right? Because as I said earlier, that is, see, one section definitely is the scheduled tribe community, the other section which is for traditional forest dwellers, and the traditional forest dwellers defined in this particular legislation is that, see, if you somebody for a number of generations, see, for almost 75 years, when you stay, depending upon the forest, right, there are multiple generations, in fact, went through, depending upon the forest and forest resources, probably would be considered as traditional forest dwellers as per the legislation. So this is where the suggestion came up, that is, you have to go for a clear segregation, right, by looking at the claims of the people on land, right? Otherwise, the issue may happen, that is, sometimes in the name of scheduled tribe community, or Adivasis or tribal community, see, there are possibility to exploit and manipulate the vulnerability of the people by the traditional forest dwellers or maybe the non-tribal community. So that is where, see, for instance, also the order, according to Justice Lokur, was saying, see, the number of claims rejected by the state government in respect of each category. So each one of the regional government can take a particular decision. So the official should carefully look at some of these things and reject the claim. Here also, what I'm saying is that, see, this is not merely a problem of the legislation. It is also the kind of nexus that right, the non-tribal people or the traditional forest dwellers, along with the bureaucrats, as well as the political community, which is creating at the local level, probably that is further, right, I mean, creating a context and a situation in which you can go for further exploitation of the tribal community, right? And that nexus which is happening, right, I mean, who is going to, right, verify all the claims? Basically, the claim, I mean, is going to be verified by the committee, in which they are saying that is all the sections of the people, right? There is a joint forest management committee should be there. The representation of the people should be there, right? All these things which are there. But what is essentially happening is that this is essentially doing, right, by the officials, the state officials, where there is a higher probability to create this kind of a nexus, and that would create a situation, and that is the experience probably you can encounter in many other societies. So that is why even Justice Loku was saying that is, right, you have to provide a clear justification of what is the reason around which you are rejecting a claim, right, which is on forest as well as land. But the problem would be who is doing this, what is the how much transparency associated with this process, whether the tribal community, I mean, is having adequate information to verify it further, right? So are they in a position to look at all these procedure, right, by their own way, in order to understand that, see whether the process was right, followed, right, strictly followed the procedure that was given in the legislation. If that is not happening, right, probably there are instances and there are possibilities, right, where definitely this legislation would be, right, misused a lot, right? So that's what I'm saying, and I'll stop here. So he was also saying that is, he was saying the status of eviction of those claimants whose claims have been rejected and the total extent of area from which they have been evicted. Right? See, suppose if you know that a lot of eviction is happening. See, that eviction again on the basis of this, right? If you are making a claim on a land or a forest, and through a procedure, right, they will be identifying that you are not eligible for this. Definitely, you will be evicted from that, right? So this is what we are saying. That is, in the name of this process, if the tribal community, right, or the sections of the people who are genuinely deserving some of the provisions are evicted as a result of this process, then probably we are going back to the assertion that is, we are continuing the historical injustice again in a much more nuanced manner to the community, right? So eventually that will end up like that. But I mean, I'll stop here. So I mean, there are instances where you can find that, especially suppose if you take Vidarbha region, where there are studies which are coming up, where Vidarbha is an exceptional region in which, right, one of the regions, I mean, in Maharashtra, as well as, I mean, in compared with other states in the country, where there is an effective implementation of the Forest Rights Act 2006 happen, right? I mean, of course, we need to go for further and further studies by looking at the heterogeneity, as I said, the heterogeneity of the community and how much they got, I mean, benefit out of this. But this is the larger impression and this is the larger finding which is coming through the studies, where, right, saying that is, this region definitely is showing an interesting, right, an interesting case in which the implementation of Forest Rights Act and the collective claim of the people and collective claim of the community over land was largely accepted, where the implementation, and there are factors associated with that effective implementation, but that is the some of the studies which are pointed out, right? So that's what I mean, I would like to talk about the Forest Rights Act 2006.
So I think this sums up our discussion here. Thank you so much for being available and contributing to this podcast. I, on behalf of my co-host and the Legal Aid Committee of MNLU, I'm thanking you for this. Thank you so much, sir.
Yeah, So yeah, thank you so much for the conversation.